The Supreme Court just dropped a ruling that every gun owner in America needs to hear about right now. And I am not talking about some minor procedural tweak or a footnote buried in a legal opinion. I am talking about a fundamental shift in how this country thinks about your right to carry a firearm. A shift that affects over 100 million Americans. A shift that state governments are scrambling to respond to. A shift that most people still do not fully understand, and that misunderstanding could cost them dearly. If you have ever applied for a carry permit and got denied, if you have ever been told your reason was not good enough, if you have ever had a government official look at your application and decide that your life, your neighborhood, your job, your fear was not serious enough to justify your constitutional right, this ruling is for you. Because that system, it is dead. The Supreme Court killed it, and they did not just tweak the law, they took a sledgehammer to the entire foundation of how states issue gun permits. Before we go any further, are you subscribed? Because what I am about to break down is the kind of information that separates people who know their rights from people who accidentally waive them. Laws are changing in real time, and staying ahead of every single update is not optional anymore. Do not be the last person in your state to find out your rights just got bigger. Let us get into it. To understand why this ruling matters so much, you need to understand how broken the old system was. For over 100 years, a group of states operated under what is called a may-issue permitting system. The name tells you everything. The state may issue you a permit, or they may not, entirely up to them. In states like New York, California, New Jersey, Maryland, Massachusetts, and Hawaii, you could not just apply for a concealed carry permit and expect to get one. You had to prove something. You had to demonstrate what they called proper cause or justifiable need. You had to convince a government official, someone you have never met, someone who does not know you, someone who will never walk in your shoes, that your personal reason for wanting to carry a firearm was serious enough to deserve a constitutional right. Think about that for a second. You had to audition for a right that the Constitution already guarantees you. In New York City, if you were a small business owner who carried cash deposits to the bank twice a week, you applied for a permit, you explained your situation, and the licensing division told you, not good enough. Plenty of people carry cash. You are not special. Denied. In California, if a woman was being stalked by an ex-partner, if she had text messages, if she filed police reports, if she had a restraining order, she still had to go before a county sheriff and hope that official personally believed her fear was real enough. If the sheriff had a different opinion, denied. In New Jersey, the justifiable need standard was so strict that if you did not have a dangerous job or a specific documented threat, you were getting denied. Period. You could want a permit for general self-defense, the exact reason the Second Amendment exists, and New Jersey would laugh you out of the building. This was not a fringe situation. Over 100 million Americans lived under these systems. That is roughly a third of the entire country. And for decades, courts largely let states get away with it, until two men in New York decided enough was enough. The case is New York State Rifle and Pistol Association versus Bruen, decided June 23, 2022, a 6-3 decision. Justice Clarence Thomas wrote the majority opinion. Here is what happened. Two law-abiding New York residents applied for unrestricted concealed carry licenses. They did not have dangerous jobs. Nobody was threatening them. They just wanted to carry a handgun for general self-defense. The same reason millions of Americans carry every day in states that actually respect the Second Amendment. New York said no. General self-defense is not a good enough reason. You need something more specific. So they sued. They argued that the Second Amendment gives law-abiding citizens the right to carry a handgun outside the home for self-defense, and that New York's proper cause requirement violated that right. The case went all the way to the Supreme Court, and the Supreme Court sided with them decisively. Justice Thomas wrote that the Second Amendment protects the right to carry a handgun in public for self-defense, not just in your home, not just on your property, in public, on the street, in your daily life. He looked at American history going back to the founding era, examined laws from the 1700s and 1800s, and concluded that nothing in that history supports a system where government officials get to deny carry permits based on their own subjective judgment about whether someone needs to carry. The court said it plainly. If you are a law-abiding citizen, you have the right to carry. The state cannot force you to justify that right to a bureaucrat. The Second Amendment is the justification. That is all you need. The three dissenting justices argued that states should have more flexibility to regulate public carry, given modern gun violence realities. They pointed to statistics. They pointed to mass shootings. They said public safety concerns should weigh more heavily. But the majority responded clearly. Constitutional rights do not disappear because the government claims restricting them will make things safer. If that logic worked, no right would be safe. You would lose your First Amendment rights the moment someone argued that free speech causes harm. Rights come first. You regulate within their limits. You do not eliminate the right because you are afraid of it. Justice Thomas made the point even more directly. The Second Amendment is not a second-class right. You do not need a special reason to exercise your First Amendment right to speak. You do not need proper cause to exercise your Fourth Amendment right against unreasonable searches. And from this moment forward, you do not need to prove a special need to carry a firearm for self-defense in public. Now here is the practical bottom line, and pay attention because this is the part most people get wrong. May issue is dead. Shall issue is the new national standard. What is the difference? Under may issue, the state decides whether to give you a permit based on whether they think you deserve it. Under shall issue, the state shall give you a permit if you meet the legal requirements. It is not a choice anymore. It is not discretionary. If you are a law-abiding adult with no disqualifying criminal history, no mental health prohibitions, and you complete whatever training your state requires, the state has to issue you a permit. They do not get to say no because your reason is not good enough. They do not get to say no because they do not think your neighborhood is dangerous enough. The permit process has to be objective. Meet the criteria, get the permit. And this is not just affecting New York. California updated its concealed carry laws in direct response to Bruen. New Jersey rewrote its permit system. Maryland changed its requirements. Massachusetts had to comply. Hawaii had to comply. Every single may-issue state in the country had to change how they operate. Thousands of people who were denied permits under the old system have now been approved. People who were told their fear was not real enough, their job was not dangerous enough, their neighborhood was not bad enough, those people are now walking around with permits they were unjustly denied for years. In New Jersey alone, the number of carry permits issued soared by nearly 5,000% after the Bruen decision. That is not a hypothetical. That is what is happening right now in states across the country. Here is the part of this ruling that most people completely miss, and it might actually be more important than the permit issue itself. Bruen did not just kill may-issue permitting, it changed the entire legal framework courts use to evaluate gun laws going forward. Before Bruen, courts used something called intermediate scrutiny. Under that standard, the government just had to show that a gun law was reasonably related to an important government interest, public safety, for example. That is an easy bar to clear. Courts rubber-stamped gun control laws constantly. Gun rights groups kept losing because the legal test was stacked against them. Bruen threw that test out entirely. Now the government has to prove that any gun regulation fits within the historical tradition of firearm regulation in America. Specifically, courts look at whether similar laws existed at the time the Second Amendment was ratified in 1791. If you cannot find a historical analog from the founding era, your modern gun regulation is in serious constitutional trouble. That is a dramatically higher bar, and it is being used right now to challenge laws all over the country. Assault weapon bans, magazine capacity limits, waiting periods, licensing schemes, all of them are being challenged under the Bruen standard. Courts are being forced to ask whether laws like these existed in 1791, and in many cases they did not, which means those laws are losing in court, which means the Second Amendment is getting stronger with every passing year under this new framework. The states that lost did not just roll over, and you need to know what they did because it directly affects what you can and cannot do in your state right now. New York passed the Concealed Carry Improvement Act within weeks of the Bruen decision. They could not require proper cause anymore, so they found another angle. They expanded the list of sensitive locations where guns are banned, drastically. Bars, restaurants, public transit, Times Square, parks, entertainment venues, houses of worship, healthcare facilities, playgrounds, libraries. California followed with SB 2. These laws were designed to circumvent the Supreme Court by creating a minefield of new requirements and no-go zones. Think about the trap they set. If you have a permit, but you have to walk across a park to get to your car, or you step onto a subway to get to work, you are suddenly a felon. They are trying to make it legally impossible to travel from point A to point B without accidentally committing a crime. New York also tried something even more radical. They required permit applicants to hand over a list of their social media accounts for the last 3 years. Government bureaucrats would scroll through your Instagram and Twitter to decide if you have good moral character. This is a First Amendment violation stacked on top of a Second Amendment violation. It is a loyalty test for a constitutional right. And then there is what can only be described as the vampire rule. Historically in America, if a business is open to the public, like a grocery store or a gas station, it is presumed you can carry unless there is a no-gun sign posted. New York and California tried to flip that entirely. They passed laws saying carry is automatically banned on all private property open to the public unless the owner puts up a sign specifically welcoming firearms. They know most business owners do not want to get involved in politics, so most will not put up that sign. By doing this, the state effectively bans you from every store, pharmacy, and shop without passing a single explicit ban. Here's the good news on all three of those fronts. The courts are already dismantling them. Federal judges have been issuing outstanding injunctions. The social media requirement has been flagged as a constitutional bridge too far. The vampire rule has been challenged and blocked in multiple jurisdictions. The sensitive places expansion is being carved apart piece by piece. But, and this is critical, it is a moving target. Laws that were struck down yesterday may have a new version passed today. Just because you have a permit does not mean the ground beneath your feet is legally safe until the final court orders are settled. Now I need to address something that happened in 2024 that some people have been misrepresenting. The Supreme Court issued a ruling in United States versus Raheem. Some anti-gun groups immediately claimed this reversed Bruen. That is completely false. Raheem was about one specific question. Can the government disarm someone who is under a domestic violence restraining order and has been found to be a credible threat? The court said yes, but Chief Justice Roberts made it explicitly clear the history and tradition test still stands. Bruen was not reversed. Bruen was reaffirmed. What Raheem did was clarify that the government does not need a historical twin, just a historical cousin. It gave the government a little more breathing room in specific circumstances involving proven dangerous individuals. It did not bring back May issue. Your right to a permit is still protected. Now let me clear up the three biggest myths spreading right now because one of them could get you arrested. Myth 1, Bruen means you can carry anywhere without a permit. That is completely wrong. The Supreme Court struck down May issue systems. It did not eliminate permit requirements. If your state requires a permit to carry, you still need that permit. Do not skip the process because you heard everything changed. Myth 2, gun-free zones are now unconstitutional. Not exactly. The court acknowledged that some sensitive places can legitimately restrict firearms, schools and government buildings, for example. What Bruen did was raise the bar for which locations qualify. You can still be arrested in a designated gun-free zone while litigation is ongoing. Challenge it later if you must, but from a very uncomfortable position. Myth 3. Bruen only matters for concealed carry. The constitutional principle applies to all public carry. Open carry bans are already being challenged using Bruen as the foundation, and those cases are working through federal courts right now. Now let us talk about what is coming next, because the legal landscape in 2025 and 2026 is moving fast. The Supreme Court is currently examining a major case out of Hawaii called Woolford versus Lopez, which challenges the vampire rule at the national level. During oral arguments in early 2026, the justices signaled deep skepticism toward these sweeping private property bans. If the court strikes this down, it will dismantle the single biggest remaining hurdle for permit holders in blue states. Your right to bear arms would no longer vanish the moment you stepped into a grocery store or a coffee shop. Several cases are also racing toward the Supreme Court regarding assault weapon bans and magazine capacity limits. In Maryland, the case Snope versus Brown is testing whether the AR-15, the most popular rifle in America, can be banned. Under the Bruen test, the state has to find a historical law from 1791 that bans a specific type of rifle. They cannot. Cases like Duncan versus Bonta out of California are challenging the 10-round magazine limit using the same logic. If the court rules that standard capacity magazines are protected, the 10-round limit becomes a relic overnight. To keep yourself out of a courtroom while all of this is in motion, here is what you need to do. First, track sensitive place designations in your state in real time. The list changes faster than most people realize. Apps like USCCA or Legal Heat give you up-to-date maps. Second, get your training done now and get it documented. States are using training requirements as a delay tactic, and the higher your paperwork bar, the harder it is for a discretionary denial to stick. Third, and this is the one people underestimate, operate by what you might call the respectful carry principle. Even though your rights are expanding, your responsibility is expanding with them. In the eyes of a blue state prosecutor, a permit holder who ends up in any kind of confrontation is someone who was looking for trouble. Prove them wrong by being the most calm, de-escalating, law-abiding person in the room. This is bigger than politics. It is not about left versus right or what party you voted for. It is about something more fundamental than all of that. It is about whether you, as an individual, get to make decisions about your own safety, or whether a government official you have never met gets to make that decision for you. The May issue system was not just inconvenient, it was insulting. It said your judgment about your own life does not matter. It said a clerk in a permit office knows better than you whether you face real danger. Bruen rejects that entirely. It says you are a competent adult. You know your life. You know the risks you face. The Constitution trusts you to make decisions about your own protection. The era of courts rubber-stamping gun control laws under weak legal standards is over. The government has to do real historical work to justify gun regulations now. And a lot of laws that have been on the books for decades were never designed to survive that kind of scrutiny. The battle for the Second Amendment has shifted. It is no longer about whether we have the right. That question is settled. Now it is a battle of attrition. The states want to make carrying too expensive, too legally risky, and too socially complicated to bother. Your job is to stay informed so they cannot trap you with ignorance. Drop a comment below. Have you applied for your permit since the Bruen ruling? How long did it take? What state are you in? I want to expose the states that are still dragging their feet versus the ones following the law. If this breakdown helped you understand your rights, share it with someone who needs to see it. Because in a legal landscape that changes this fast, the most dangerous thing you can be is uninformed. Stay safe, stay legal, and we will see you in the next one.